Hello and good morning. I'm Bruce Weber, Willem Quaker Dean of the Zicklin School of Business here at Baruch College. I'm pleased to welcome you to this episode of Zicklin Talks Business. Today, we will examine executive compensation and fairness to shareholders, and we'll look at the question, should there be any limits on CEO compensation? This topic was brought into sharp focus by a January ruling in the Delaware Court of Chancery that found Tesla failed to prove the fairness of the compensation plan for their CEO and product architect, Elon Musk. The court rescinded the $56 billion pay package, upsetting Musk and Tesla's board that approved the plan. Joining us to discuss this issue with our school's namesake, Larry Zicklin, Baruch class of 1957, are Jaron Van Creusen and Gregory Varallo of Bernstein, Litowitz, Berger, and Grossman LLP. My colleague, Associate Dean Gwen Webb, will moderate the Q&A session at the end. First, let me introduce Jaron. Jaron Van Creusen is leading U.S. shareholder lawyer and a member of the executive committee of BLB&G's, and he heads up its corporate governance practice. He oversees breach of fiduciary duty litigation on behalf of shareholders against boards and senior executives. Over the course of his career, Jerome has recovered over $4 billion for investors and improved corporate governance practices at numerous companies. He's been named one of Law Dragon's 500 leading lawyers in America, and Benchmark named him a litigation star. Jerome is a board member of Legal Services NYC, one of the largest legal aid organizations in the United States, providing legal assistance to more than 100,000 New Yorkers every year, including immigrants, veterans, elderly, and people with disabilities. He graduated with a JD from Columbia Law School in 2003, previously earned an LLM at the University of Amsterdam School of Law. Joining Jerome is his colleague, Greg Varallo, who heads BLB&G's Delaware office. Greg focuses his practice on protecting investor rights, trying cases in Delaware and around the U.S. Prior to joining the firm, Greg served with corporate defense firm Richards, Leighton & Finger for 36 years, 3 as firm president, representing major corporations on various Delaware business matters. He's litigated hundreds of complex business disputes and earned his reputation among the country's leading corporate governance experts and trial lawyers. Greg has been recognized as one of the nation's leading business litigators by Chambers USA and also been named a litigation star by Benchmark and a top lawyer by Delaware Today. He's a frequent speaker and co-authored several publications, including the Practitioner's Guide to the Delaware Rapid Arbitration Act and the Fundamentals of Corporate Governance. After his undergraduate studies, Greg earned his JD from Temple University School of Law in 1993. And with that, I'll pass it over to my friend and colleague, Larry Zicklin. Larry.
Thank you, Bruce. So to get started, for those in our audience who might not be knowledgeable about this case, the Musk-Tesla pay package controversy, can you set up the webinar by talking to us about what happened in 2018 that engendered this controversy? And either one of you can do that.
Greg, do you want to start with that?
Sure.
And actually, before we do that, can I just say one preliminary comment? First of all, thank you for having us. We're very, very pleased to be here with you and your audience to talk about this case. And really, thank you for having us. The second thing I want to say is, I want to make sure that you understand that the views that we're going to give here are our own personal views. They're not necessarily the views of our firm. They're not necessarily the views of our clients. But Greg, if you want to set up what happened in 2018, that would be awesome.
Sure. So Mr. Musk, as CEO of Tesla, had been compensated by the company with a plan that was designed in 2012. At the time, it was the largest compensation package in history. It had 10 tranches. It had goals. And by mid-2017, a number of those goals had been met, and the board began to look at the question of whether it would be appropriate to design a new package. In April of that year, the chairman of the compensation committee and Mr. Musk had a chat. Mr. Musk asked during that chat for a new plan, gave some guidelines or suggestions as to what the plan should look like. and off went the Tesla machine to design a new plan for Mr. Musk. Interestingly, they didn't abrogate the old plan. The old plan stayed in place. And in 2018, when the board adopted the new plan, which Mr. Musk described as high risk and, quote, really crazy, close quote, the old plan was never changed. So at that point, and right up until the expiration of the old plan, which was in August of 2022, Mr. Musk also had the opportunity to earn at least one tranche under the old plan that hadn't been earned. So the plan, as adopted in January of 2018 by the board, contemplated 12 tranches. Mr. Musk would get roughly 1% of the company for each tranche. And a tranche was earned when a market cap goal was met and an EBITDA or revenue goal was met. And as it turned out, Mr. Musk was successful at earning all 12 tranches of the new 2018 plan.
And that resulted in roughly $56 billion worth of shares in the company. Rough.
Options to purchase roughly $55 billion worth of shares. That's right. But what's $1 billion between friends, Larry?
Yeah. Let's not argue about $1 billion. And what was it about that pay package that engendered the suit that the two of you, plus one other lawyer that I know you mentioned once before, was filed? What was there about that plan that you found objectionable?
So I think I'll take this one. So initially, there were two other firms that brought the case. So Greg and I and our firm, we were not involved. And they brought the case, and I'm simplifying a little bit, but the genesis of it was basically too much. And the court, this is all pending in the Delaware Chancery Court, and then Vice Chancellor Slights, who is now no longer on the bench, denied the motion to dismiss, and the case was going to go into discovery. And then the other firms, they came to us and they said, would you like to join the case? Because we know that your firm and you have a lot of trial experience, and Elon Musk is unlikely to settle. And so that's when Greg and I became involved in the case. Happy to take it from there, but that's also when we changed some of the focus of the case and ultimately litigated the case we did.
So here is a plaintiff, as I recall, with 9 shares of stock, going up against ostensibly the richest man in the world and one of the most powerful men in the world. Why did you take this case?
You know, our Supreme Court has a motto over the building it sits in, and the motto is equal justice under law. And I'm stealing Jeroen's thunder here because he mentioned this to me earlier, but you know, Larry, I don't think there's a better example of this in practice than this case. The idea of equal justice under law, the idea that someone with 9 shares can challenge the world's richest man in a court in Delaware without a jury, a single assignment judge, and this judge can decree after a full trial on the merits that this was a breach of duty. It's an amazing thing. It's an amazing thing. It sets Delaware apart from many jurisdictions. In fact, it sets Delaware apart from many other legal systems that this was even possible. And it was possible because we had a courageous judge and, frankly, a courageous client who was willing to stand up to the power associated with being the richest man in the world. Why did we take it? Because we analyzed it and we concluded that perhaps the disclosures that went to shareholders around this package were seriously deficient. And in fact, we were able to prove that they were materially misleading. You know, Larry, I should say, one of the things you'll find out about Jeroen and I is we're capitalists. We believe at the end of the day in the capitalist system. But the system doesn't work if you lie to shareholders and then make the plan contingent upon shareholder approval. And when we got into this, we concluded that there were some really significant and material misstatements of fact in the proxy statement that went out to shareholders for the 2018 vote. And that's largely how we crafted our attack.
Can I just add one thing?
Go ahead.
Yeah. So Greg is 100% right, and I just wanted to add two things. One is this case is one of the reasons why I'm proud to be American. I do not know, and I've become an American, so maybe that's part of it, but I do not know of a single country, and that includes countries in Europe, including the Netherlands, where I'm originally from, where you could have this situation, where you have a small shareholder get this kind of treatment under the law, equal for all, challenging the richest person in the world and win. Like it is a remarkable feature of our legal system, and I think it is an amazing feature of our legal system. The second thing I was going to add is the title of this meeting, this webinar, is whether there should be limits on the level of compensation for CEOs. And both Greg and I would answer that with no. This is not about too much. This is about the way in which. And you need to be honest. There needs to be a proper process. But if the proper process had been followed and the shareholders had not been lied to, we would not have taken this case. And this would not have been the decision that we have.
My father was an immigrant, and Pop used to say to me all the time, only in America could this happen, pointing to something or other. I wish it were as true today as it was years ago, but that's a different story. Tell me about what you found deficient in the original documents that were filed and given to the public when this plan was first announced in 2018. Where were the problems?
Number of them, and you and I can do this in parts, but
yeah.
One of the real issues here was the proxy's description of the decision makers. Shareholders were told that each of these directors was sort of vigorously independent, with two exceptions, Mr. Musk and his brother Kimball Musk. They're told that all the other directors were independent directors, and that they followed a process which was effectively replicating an arm's length process. We proved it just wasn't true. A number of these directors were close personal friends with Mr. Musk. Their families vacationed together. They shared common investments. They had known each other for years and years and years. That was one category of concerns. Another category of concerns, and this is something Jeroen developed in discovery of the CFO of the company, was even more stark. And that was at a time when the stockholders were being told that each of the 12 tranches of this plan were designed to be very difficult to achieve. That's what the stockholders were told. At the same time, effective as of the date of the vote, Tesla's internal working group that supplied information to the audit committee of the firm concluded, for accounting purposes, that it was at least 70% probable that within 12 months, Mr. Musk would achieve the first three of these 12 tranches. Put differently, a quarter of the value of this plan would be achieved within a year, with a 70% probability if the company merely met its projections.
So that's $14 billion at 70% would be like $10 billion using 70% of 14 billion.
Yeah, I think that's correct.
That's a stunning misstatement. I would call it a lie, but we call it in the law a material misstatement of fact.
But Greg, you didn't know that going into the case, did you? Because you didn't know what the internal documents said.
We had access to certain documents, and we developed a record as we went, is the answer to your question.
So the risk you took going in was enormous.
It always is as a contingent fee lawyer. Yes, that's true.
Okay, and were these directors, both the ones that were friendly and the ones, I guess they were all friendly, highly compensated? Was that a conflict?
Well, let's talk about that, because that's one of the findings of the court that's very interesting. The current chairman of the board is a woman by the name of Robin Denholm. And Ms. Denholm had a successful career in public company practice, largely as a CFO. And her last job before becoming chairman of the board of Tesla was as the CFO of a large Australian communications company called Telstra. And when Ms. Denholm joined the board in 2014, she was given a 3-year award of options. By 2018, the trial took place in 2022.
22.
By 2022, she had sold a small sliver of those options and generated a return of in excess of 200 billion. So that I'm sorry, 200 million US dollars, 200 million US dollars, which she admitted was life-changing wealth. At the time of trial, the options that she hadn't sold were worth roughly 750 million additional dollars, all in, again, roughly $1 billion in value. But the first 200 million was achieved within 3 years, and within roughly 5 years of her joining, those options were worth close to $1 billion. Now, look, Ms. Denholm was not impecunious. She had worked for public companies before. She had made a reasonable amount of money in public company service, but not hundreds of millions of dollars and not billions of dollars. And she was candid when she said that the value she achieved from her Tesla board service was, quote, life-changing, close quote. And the court focused on that and quoted that. That is a real challenge to independence of directors when they're being handed hundreds of millions of dollars in compensation. You know, the average director of a listed company makes somewhere between $300,000 and $400,000 a year in compensation. And I'm talking about a large listed company. I'm talking about Goldman Sachs or JP Morgan. Yes, occasionally they make more, but on average, these large company directors make $300,000, $400,000, $500,000 a year, not tens of millions or hundreds of millions of dollars a year, except if you're a Tesla director.
Let me add something, because your audience may be wondering, why does it matter, right? And I think it is important to understand that when you think about corporations, the shareholders provide the capital, and then they elect the board of directors to oversee the company and the operations of the company. And effectively, the directors are the agents of the shareholders. And so when they are negotiating a compensation package with the CEO, it really is important that they're independent from the CEO so that they can understand, okay, what is in the best interest of the company, not necessarily what can we just do to make the CEO happy. And if you don't have that independence, when people are effectively just handing over the reins of the CEO compensation to the CEO, which is what we proved here, you have a conflict. You have a conflict that is not necessarily in the best interest of the company and the shareholders. That's why it is so important that when you think about Ms. Denholm or Mr. Ehrenpreis or other directors on that board, when they are telling the shareholders, please approve this package for Elon Musk, it was negotiated on your behalf, on behalf of the company, by people who are independent from Mr. Musk. If you then uncover that they are not independent from Mr. Musk, that is a critical point for the shareholders to say, whoa, whoa, whoa. Who negotiated and for whose benefit was it really negotiated? That's why it is so important that these people were supposed to be independent and that they were not lying about their independence to the shareholders when they were asking for approval of this pay package.
So was there evidence that you uncovered that Mr. Musk really wrote this contract for himself and had the directors approve it?
So very close, very, very close. So Greg actually deposed Elon Musk as part of the case, right? So when you have the case, you go through discovery, you go through the documents, you also take depositions, which are statements under oath that are transcribed, and you have a video recording of it as well. And so Elon Musk was Greg deposed Elon Musk. And as he deposed Elon Musk, one of the things that Elon admitted after we showed him a number of documents and emails was that on critical points, he was really, quote, negotiating this with himself. And so, yes, we uncovered evidence that this process was really corrupted by the lack of oversight of independent directors, allowing Elon Musk to design this plan for himself effectively.
Wow. That is very interesting. And when you did this case, this is such an enormous case. Did you wonder about whether you had the capacity to try a case like this? You know, $56 billion. That's a lot of money, even if you say it fast.
Well, I'm going to leave this to Greg because Greg never lacks in confidence. So I'm going to leave it to Greg to answer this one.
You know, we knew when we came into the case that we're up against one of the leading firms in the country, Cravath, Swaine & Moore, based in New York, and the leader of that firm was an old friend of mine, the former chairman of the firm, a guy by the name of Evan Chesler, who's an outstanding trial lawyer. So we knew we were facing some of the best trial lawyers that money could buy. And frankly, I'm very proud of our team here, Larry. We built a team under Jeroen's leadership and under Max Berger's leadership as well, which I think can go toe to toe with anybody in the country. And I think we proved it in this case. We put together a terrific team. And as Jeroen pointed out earlier, we were brought into this case to try the case, but we're brought in by some other very fine lawyers who had some fine trial lawyers on their team as well. And as a group, we took this to Cravath and we did our very best. And you know, some days it works out, and this is one of the times it worked out. But I'm very proud of our trial team, and we knew exactly what we were doing, and we knew exactly who we were up against.
When you went into this case and you knew who you were up against, how did you make the odds that you would win?
No comment. Look, look, this was a case where we thought we had a real shot. We knew we had an excellent judge, and the Court of Chancery is one of the finest courts, if not the finest business court in the country. We knew that Mr. Musk had a habit of constantly providing evidence. One of the problems we faced here, Larry, was not finding evidence to cross-examine Mr. Musk, but weeding through the mountains of evidence that he produces on Twitter every single day. It is literally true that one of our trial teams spent almost a month going through all of his Twitter feed to select cross-examination exhibits that we used at trial. And we had to narrow down thousands of possible exhibits to use because he's just so prolific at what he puts out there. And we knew as well that the sheer size of this at least would give one pause, although its sheer size alone is not a legal theory. We knew it was enough to get the attention of the decision makers. And as we developed the case further in discovery, we found a lot of things we liked and pushed forward.
And you mentioned the judge. How was the judge chosen, since we've heard a lot about choosing judges these days?
So our judicial system in Delaware is effectively a merit selection process. When a judgeship is open, there's a group called the Judicial Nominating Commission that's made up of is a gubernatorially appointed commission. It's made up of lawyers and non-lawyer citizens. And that group publishes for the opening. It considers the candidates who come before the commission and submit interest in becoming a judge. The commission gives 3 names to the governor. The governor selects one of the 3 names and the Senate confirms. So it's a largely apolitical process. It is not an elected judiciary, and the judges sit for 12 years. This particular judge started off as a member of the court that we're in, the Court of Chancery. She started off as vice chancellor. And when the prior chancellor resigned some number of years ago, she submitted her name and was selected by the governor on the recommendation of the Judicial Nominating Commission to serve the role as chancellor, where she's served for, I don't know, you're in 3 years or so now?
Yeah, and the other thing I think is important is all judges in the Chancery Court are very well respected by both defense lawyers and plaintiffs' lawyers. They're very professional, apolitical, as Greg said, and extremely knowledgeable about corporate law issues, which of course is sort of a niche practice. But because they're so knowledgeable and apolitical, they're widely respected. You will never hear a prominent defense lawyer say something negative about any of these judges, and nor would you hear any respectable shareholder lawyer ever say anything negative, because they are really trying to do the best thing they can and give the right decision without any political input.
I'm wondering how a decision like this was made by the firm to get into this litigation, because I'm assuming this is very expensive litigation. You're gathering witnesses, you're interviewing, you're doing research, you've got travel costs, you've got, God knows, how long did it take you to prepare this case? Maybe that's the beginning.
Well, let me start by saying how we decided to get into the case. So answer your first question. So when the other firms came to us, we looked at the then current status of the case, and we had a lot of internal discussions, including with
what year is this, Jerome?
So this was in 2020, maybe 2021, early 2021. And we had a lot of discussions internal also with the leadership of the firm at the time to talk through the potential benefits and also the potential risks. And we all concluded, not just Greg and I, but everybody who was part of those discussions, including Max, that this should, if this was a case purely about the magnitude of the plan for Elon Musk, it was not the kind of case that we wanted to take, because we believe that ultimately the shareholders and the directors, if they're acting appropriately, are more appropriate for deciding CEO compensation than a court. And so as we were talking it through, though, we understood more and more like that there are some serious problems with this plan in this circumstance, because we started to look at the independence or the lack of independence of the directors. And as we started thinking about it, we were like, okay, well, it is really important as a shareholder firm, which we are, that we stand up for the rights of the shareholders. So that became a positive, right? If the shareholders are lied to, that is the kind of case that we would take, whether it's a securities class action that some of our colleagues do, or whether it's a breach of fiduciary duty action that we would do. But if shareholders are being harmed, that is a core practice. That is our core practice, right? And so we started looking at it through that lens. And then it became fairly easy for us to say, look, we see these lack of independence. We see that this package is really problematic already now. This is the kind of case that we are willing to put our resources in. And then, as Greg already said, as we started developing the evidence, the likelihood of probability that these tranches would vest very early, the case became stronger and stronger. But I think that was, generally speaking, the nature of the decision-making process.
By the way, you mentioned breach of fiduciary responsibility. If the directors breached, does that make them liable?
So the remedy given here, in many cases, the answer is yes. That's why many firms, public firms, carry directors and officers insurance to stand behind the directors in the event they're found liable. In this particular case, what the court decided to do was, rather than assess a damages number, the court found that the preferable remedy for the wrongs we had proven was to rescind the plan, or to put differently in non-lawyer language, to cancel the plan altogether. So, as part of the court's decision, which was issued this past January, the court gave a decree of rescission, which meant that the options were effectively canceled. So that's how the court dealt with this particular remedy.
And so just to add on to that, so I mentioned earlier how you have the shareholders who elect the directors to oversee the company. Those directors owe fiduciary duties to the company and to the shareholders. Duty of care, duty of loyalty, must act in good faith. And so in other cases where you have financial harm to the company, for example, it is possible that a director is liable for breaching his or her duty of loyalty. But here we had a different paradigm. We said that this plan was not entirely fair to the company. And so there was not going to be a monetary liability awarded against these directors, although they did breach their fiduciary duties in the way they constructed this plan and the way they disclosed it to the shareholders.
Normally, in a case like this, the burden of proof is on you to demonstrate whatever you want to demonstrate. Was it different in this case because Musk was a controlling shareholder?
It
The answer
was.
is yes. Go ahead, Greg.
It was, but it's not solely because Musk was a controlling shareholder. The court found that Musk, to be clear, that Musk controlled this particular decision, but not that he was a controlling shareholder overall. So the court limited its findings on control. There are two or three other reasons, though, why the burden shifted here. One reason was the decision was made by a board made up of directors who were not independent. And lacking independent directors, there's often a burden shift. In addition, in this particular case, the court asked the question at closing argument, very distinct and clear question, whether if she found that there were material misstatements of fact in the proxy that was used to solicit stockholder approval of this plan, what the outcome of that should be. And the defendants, Mr. Musk's lawyers, responded that the outcome should be the burden shift that the court utilized. That is to say that the defendants had to prove the fairness of the process and the so-called price because of the material misleading statement of fact. So the court had several bases upon which to shift the burden here. The finding of control in this particular circumstance, the finding that the directors were not independent, and the invitation of the defendants themselves based on the court's finding that there were material misstatements of fact in the proxy.
Could there have been a settlement of this case before a decision was made? Was that ever a discussion?
We can't get into discussions we may or may not have had surrounding settlement, but let me say this. Compensation cases are notoriously easy to settle. If both sides want to settle, this case could have been settled many, many different ways because of the many levers in the control of both sides if they had wanted to negotiate. Let me just say that the facts speak for themselves. The case wasn't settled.
How many witnesses did you call?
Our firm handled 8. I believe there were another 3 or 4 overall. I think we had 12 altogether.
Did Musk testify?
He did.
Who cross-examined him?
I did.
Can you talk about what that was like?
Sure. I've told this story once before, but I'll tell it again.
Yeah, but we've never heard it before.
That's fair. When you're in law school and you learn about cross-examination, you're told as a young lawyer, never ask a question you don't know the answer to. It's critically important that you control the narrative that's told by the witness, that you control the witness in cross-examination at trial. And one of the things I had learned about Mr. Musk, having deposed him, spent a day visiting with him and taking his testimony prior to trial, was that like most CEOs, he had a desire to exert his control in the room. And I will say about Elon, he's an enormously intelligent individual, but he loves to hear himself talk. And early on in the examination at trial, I asked him a fairly straightforward question. It could have been something as simple as, was it a sunny day or not? It called for a yes or no answer. It was a simple question. And he began to tell me every thought he had ever had since he was born. Let me tell you this. It's not a yes or no answer, Mr. Perella. Let me tell you about this. And he spoke. And my instinct, let me put it this way. My training would have been to stop him and say, Your Honor, I need an answer to that question. I'm on the clock, because in Delaware, you only have so much time for a trial, and each side is allotted, half the time. And if I'm talking in court or my witness is talking, that counts against my time. So there's an imperative to get straightforward answers. But my instinct was, no, let him talk. And the more I let him talk, the more he talked. And he went on for, I think in the transcript, it's about 6 pages in this answer that should have been yes or no. And I walked around the courtroom and I passed important notes to my colleagues, and I whispered in one of my colleagues' ears, and I turned my back to the witness, and I just let him go. My instinct was that if I let him go long enough, he would say something really useful that we could come back on. And after 6 pages, the court leaned into the microphone, the judge leaned into the microphone and said, "Mr. Musk, this has been fascinating, but I've forgotten the question. Do you know what the question was?" And Musk looked at her with this look of surprise on his face, and he said, "No, Your Honor, I've forgotten the question too." And I was able to round it out by saying, we can have it reread, Your Honor, but I've long ago forgotten the question. And from that point forward, for the rest of the examination, he behaved. He answered the question that was put to him. He didn't go off script. He gave me answers that were consistent with his deposition. And if he didn't, I was able to impeach him. But my ability to control the witness was gained through letting go, by letting him try. And it was a really interesting and different moment. Not the typical way you try a case, but in this case, it worked very, very well.
I know you're not a mind reader, but what arguments do you think particularly resonated with the judge in this case?
One of the things the judge was amused by, sort of took us to task for, but then relied upon, was the argument that Elon gave us that he was negotiating with himself. In the deposition, we asked him, how did you get from X to Y? And he said, well, I guess I was negotiating with myself. And we used that to great effect, because as Jeroen pointed out earlier, in the compensation arrangement, it's supposed to be the independent members of the board that are negotiating with the CEO to get to a reasonable and fair package for the CEO. But there wasn't that negotiation. There wasn't the back and forth you'd expect in the ordinary public company or even private company context. And so Elon said it best, I negotiated with himself, he said. And so we used that quite a number of times. And I think that the court picked up on that and cited it in her quite long and detailed and well-constructed opinion, and even teased us a little bit for using it so much. But I think the court found that to be an important piece of evidence.
Let me add, I think in general, we made a concerted, we always do, but also here, made a very concerted efforts to stay tight with the facts and the law. There were not a lot of sweeping statements. We really tried to be very precise and talk about this particular fact in connection with these particular cases. No grand statements, no overstatements, to also show the judge that she could rely on what we were telling her in our briefs and in our arguments. And I think that that also resonated, because the judge would check, okay, well, they're saying that this and this and this happened, and then she would check, and it wouldn't just say that this and this and this happened, but it would be almost verbatim of what we would say, relying on the record. And so that, I think, is generally speaking, a good practice pointer for anybody who wants to be persuasive. You don't even have to be an attorney, but if you want to be persuasive in conversations, being precise and tight with the facts and your reasoning and making that transparent so that a decision maker, whether that's a judge or your boss, can look at it and figure out, okay, this is where it's coming from. I can rely that these facts are true. I'm following the reasoning, is, I think, generally speaking, very persuasive. And we did that here. And I think that that was important, in part because from my personal perspective, and I agree with everything that Greg said about the excellent lawyers on the other side, I think that they, because of the nature of their client, they may have made more broader statements that may have had a different audience, like the general public, as opposed to the judge. So I think the contrast was pretty stark from my personal perspective.
I'm trying to put myself in the position of the lawyers on the other side when Musk is talking for these 6 pages or whatever it was of testimony, and I would be dying when I heard this. That's a different story. I'm not going to get into the fee aspect of this case because I know there's some ongoing discussions, maybe litigation for all I know. But I want to talk about what is the normal way fees are determined by class action litigators in a firm such as your own.
So in Delaware, practice is a little bit different than elsewhere in the country, particularly federal court. In Delaware state court, we are rewarded for taking contingent cases based upon the court's determination of a reasonable amount, a reasonable percentage of the benefit we create. So if we go into court and create $100 benefit, and we have to try the case for that, it's not at all unusual to get 33% of that benefit, or $33 for $100 created. If we go to court and get the largest compensation package of all time rescinded, which at the time was worth something between, at the point it was rescinded, it was worth approximately $51 billion. We're entitled to ask for a reasonable percentage of the benefit we have created. There is, as you correctly point out, a huge amount of controversy about what is reasonable and what is fair in the circumstance. We will present that on briefs and an argument on July 8th to the court, and it will be up to the court's discretion as to how to compensate us. But the law contemplates that it will be a percentage of the benefit we create. That's different than federal courts, which work on an hourly basis, compensating lawyers for how many hours they worked, or so-called lodestar. So Delaware is a little bit unusual in that regard.
Well, it's enormous risk in what you did. I don't know how you compensate risk. Where do we stand now? I know there's a vote that's about to take place. Well, it's taking place as we speak, but I assume the vote is completed on Thursday, and I'm assuming there'll be an announcement very quickly after that as to whether the new pay package for Musk will be approved and whether the company will be permitted to move from Delaware to the state of Texas.
So I would, yes, but I would take issue with the characterization of the new pay package. The 2018 pay package, which has been stricken down by the court, for some reason, Tesla thinks that it's possible to revive that by going to shareholders. And what shareholders are being asked to do is to ratify, and I use that word with quotes around it, the 2018 package, to effectively somehow overrule the court's judgment and cause that package to spring to life again as though the judgment never happened. If the shareholders do that, which it's not entirely clear they will, but if they do that, there will be some further litigation about that point, Larry, because as you might expect from the tone of my answer, I think that's poppycock. I think it's nonsense, and it's not based in Delaware law. But in case you have any question as to where I stand on that, maybe I've made that clear.
I think I figured it out. And I'm assuming if that happens, that case will be heard in the Delaware Chancery Court.
The lawyers for Mr. Musk have represented to the court that that's exactly what will happen. The court issued a decision on May 28th saying that she was relying on the lawyers' statements in that regard, and if she was in any way wrong, they should tell her. No one has come forward to say otherwise. So we trust the lawyers at their word that it will happen in Delaware if that litigation needs to happen.
Let me try the other side of that. The request is denied by the shareholders. Does that end all litigation here?
No, sir. Tesla has a right to appeal the verdict of the trial court to the Delaware Supreme Court. It has said it would do so, and it will do so. There's only one level of appeal in Delaware. It's directly to the Supreme Court, and that matter would be heard by the Supreme Court later this year.
And will the decision take place this year, do you think, or will it carry over into next year?
Probably early next year, although it's possible that the decision is issued this year, but not certain by any means. I think it's slightly more likely we'll see it first quarter of 25.
And what about the reincorporation or the movement of the company from Delaware to Texas. Do you have any point of view on that? Do you care one way or the other?
You know, part of my job is to represent the best interests of Tesla and indirectly its shareholders. And I think that there's a rather curious issue here. Look, to be clear, I'm a Delaware lawyer. I've spent 41 years practicing Delaware law. I'm a proud Delaware lawyer, and I think you would be foolhardy ever to incorporate your company anywhere else. So I come to that with that prejudgment, and what I'm about to say should be understood coming from a lawyer who's practiced his whole life in Delaware. Having said that, the documents that Tesla is asking shareholders to vote upon vest exclusive jurisdiction in a particular court in Texas. That court has been authorized by Texas law, but as of today, Larry, it has no judges. There's no staff and no judges in that court. And so if on Thursday of this week, stockholders of Tesla give Tesla the vote it needs to go to Texas, and the company goes forward and reincorporates in Texas, as of Friday of this week, while you will be, as a Tesla shareholder, be required to bring suit in one court and only one court in Texas, the fact will be that there are no judges in that court. So you tell me whether that's a good thing. I suspect reasonable people could disagree on that, but I have a view which may be equally evident on that.
So let me ask you a question, Jerome. If you're a fiduciary of the retirement plan of North Carolina and you own a bunch of Tesla stock, why would you vote in favor of this proxy question to, I don't know the word to use, return Musk to this $50-odd billion compensation plan? Wouldn't you be giving away assets, or wouldn't you be diluting the stock of your fiduciary?
Well, to start with, I would not vote in favor of this ratification proposal. But I think that there's something that is very complicated that's going on. In many ways, Elon Musk right now, in my personal view, is trying to coerce people into voting for this ratification and this redomestication by essentially starting to compete with Tesla, with the new company that is called AIX. And what he essentially is doing is saying, well, if you are not paying me with the package that I want, I'm going to divert various initiatives related to AI to my new privately owned company, AIX, and I'm not going to keep those initiatives in Tesla. And that's a big problem, because if you think about Tesla, it's not just a car company. There is a massive investment going on in AI, robotics, self-driving technology, that if you take that away from Tesla and you put it in a new company, that's going to harm the stock price. So what I think is actually happening is what Mr. Musk is doing is highly inappropriate. But if I was that administrator in North Carolina, I'd be like, oh, if I don't vote for this, am I going to get harmed? Because quite frankly, the non-independent directors of Tesla are doing absolutely nothing to protect my interest as a large shareholder of Tesla. They are really enamored with the superstar CEO that is Elon Musk, and they're not telling Elon Musk, what are you thinking you're doing by taking Tesla opportunities and investments and putting them into your private company? Nobody seems to be doing anything about it. So I would have serious concerns if I was that administrator, what my vote would accomplish. But I would still vote no, because I don't like to negotiate with terrorists.
I don't see how a CEO can take assets away from a publicly owned company and transfer them on his own whim to another company.
Harry, I'm with you. You can't. Like, there are rules. You're not supposed to be doing this. Elon Musk has fiduciary duties too, as CEO, to the company and the shareholders. And the first line of defense is the board. He works for the shareholders, but the board are the agents of the shareholders. They are supposed to be holding him accountable. But these are the same people who make hundreds of millions of dollars because Elon Musk was instrumental in putting them on the board in the first place. So it's a very tricky situation at Tesla. And yeah, we're going to see how that all plays out.
Well, I don't have any shares in Tesla, but if I did and this happened, I would hire you.
Thank you.
When? What do our viewers have to say about this?
There are quite a few questions here, and there are several questions that deal with the amount of the compensation itself. So I'm going to combine two or three of them in this question. Was it a factor in the ruling that Musk is a 13% owner of Tesla and was richly rewarded by the share price appreciation since 2010 when it did its IPO? And related to this, it also deals with the amount of the compensation. And this comment was made by a couple of people in the audience. I didn't realize this case is really about whether corporate governance procedures were properly followed. In the press, I haven't even seen this particular issue mentioned. All I've seen is that the case was ruled against Musk because the compensation was deemed extremely excessive. The trial judge termed it unfathomable. Why do you think the coverage just focused on the excessive amount of the compensation?
So maybe I'll take the first and you take the second, Greg.
Go
Is
for
that
it.
good?
Go for it.
So it was so the first question was, what about the fact that Elon Musk was already a very significant shareholder by the time he got this plan, and he benefited from the increase in the stock price and the overall value of the company? That was a factor in the court's decision. And it was mostly to explain that the defendant's arguments, so the board of directors and Mr. Musk's argument, that he would be, quote, receive nothing for his efforts if the plan was struck down, was false, right? So during the case, Elon Musk and the others said, well, it would be so unfair to strike down this plan because he wouldn't actually receive anything for all his efforts for Tesla. And what the court said was, well, that's a problematic argument because for every $50 billion that the company increased the market capitalization, he would receive $10 billion, and that's nothing to sneeze at. So that was a factor in the decision, but mostly to explain that the defendant's reasoning had some holes in it. So I'll let Greg answer the second question about why there's so much focus on the unfathomable size of the package as opposed to the underlying problems in the way it was adopted in the news coverage.
So let me just add that he currently has 13%. At the time this happened, he had 21.9% because he hadn't yet sold down to buy now X, then Twitter. So he had a substantially larger block. In terms of why the coverage has focused only on the size, the unfathomable size, and the court did use the word unfathomable in the decision, that's a quote. I think it's easier in the press to talk about very simple concepts. And I think, unfortunately, our dialogue around a lot of things has been dramatically influenced by social media platforms like Twitter. Remember, Twitter started with the idea that you would have 140 characters or words, or there's a very, very limited ability to express yourself. And I think, unfortunately, our national dialogue has come down to the point where everything's a soundbite. And if you need more than a sentence or two to explain, you're just not getting, you're getting tuned out. So I think that's probably more of a commentary on the sad nature of our current state of civil discourse, but that's my view. I would also say that if you're interested, there are a couple of professors that are helping us in this matter. One is Lucian Bebchuk, and the other is Professor Robert Jackson. They have both published a series of blog pieces in the last week or so. I think they're up to 4 or 5 on this. Lucian is from Harvard Law School, and Robert is from NYU. And also Professor Ann Lipton from Tulane Law School has done a lot of blogging on this case. They have very good, insightful views describing this in general. And lastly, I want to give a shout out to my friend Lawrence Fossey, F-O-S-S-I, who is a retired lawyer, has written a lot on this as well on his blog. Any of those sources would give you a much more in-depth and interesting view as to how this fits within the larger corporate governance scheme.
Yeah,
All
I've read
right.
Dubchuk and Jackson on this stuff. Go, Gwen.
All righty, kind of along the same line. I am interested in exploring the broader ethical and economic ramifications of such substantial executive compensation. Given the vast disparities in income within companies, what frameworks could be implemented to ensure that CEO compensation aligns with both corporate performance and social responsibilities? Additionally, how might these frameworks impact corporate governance and stakeholder interests in the long term?
So that's a fascinating
And
question.
that's absolutely tailor-made for you, Yurin. Go for it.
Yeah, I know. So I have to take a step back and explain how it normally works. Not how it worked at Tesla, but how compensation is normally structured. So in a normal public company, you would have independent directors, including independent directors on a compensation committee. The compensation committee then negotiates a package with the CEO. And in order to determine what's reasonable, what's in the best interest of the company, normally speaking, the compensation committee then retains a compensation consultant that does a benchmark. And you could compare it to, I don't know if anybody knows Zillow, but you look on the real estate listings and there's like an estimated price based on the sales price of houses or real estate around whatever particular property that you're looking at. Benchmarking is the same thing. So benchmarking for compensation is the consultant makes an inventory of comparable companies, comparable in size, comparable in growth, and then comes up with a plot and says, look, if we want to reward this CEO within the 75th percentile, here's the package. If we want to reward this CEO within the 25th percentile, it's this the package, or the 99th percentile, here's the package. And that's a way of essentially tethering the compensation to objective facts. Now, there's clearly inflation because everybody goes up, the benchmark goes up, but there's at least some tethering to reality. Here in our case, the compensation committee and the compensation consultant purposefully did not do any benchmarking. They did not want to know what the comparables would be because they already knew that it was going to be so much outside the benchmark that if you would plot the 100 highest paid or the 10 or 5 highest paid CEOs at the time, 2018 here, Elon Musk's comp package would not even be on the page. And so to answer the question, one way, and actually the positive impact of this case is, one, I think it reinforces for compensation committees that they really do need to take a look at the benchmarks. And two, it takes this Elon Musk comp package out of the benchmark, right? It's no longer the case where you can just say, well, look at Elon Musk. Well, maybe I should get something entirely similar. So I think that's the positive longer term impact of this decision. Now, part of the question was also, what about broader ideas of social responsibility? Right now we get into ESG type concepts, and that's entirely appropriate for the board and the independent directors to weigh in determining the compensation. Here, clearly, because there were no independent directors, that wasn't done. But that's the typical governance structure that we work with in public companies in the United States. And so if people are really interested in ESG or social responsibility, I would say buy shares and have your vote be heard.
I would also say there's an amusing backstory here. A number of years ago, after this plan was adopted, the SEC regulations went into effect, which required issuers to disclose the delta between the lowest paid and highest paid employee in each firm. And Tesla had to do that under law. They were required to do that. And the Mercury News, which is the newspaper in the Silicon Valley, reported that in Elon's case, the distinction was something like 43,000 times between the lowest paid Tesla employee and Elon. And Elon kind of went nuts. When that got published, he went on a little bit of a tear trying to get the newspaper to withdraw the article. Of course, they couldn't because it was true. And then he, berated his juniors and his lawyers for allowing that to happen before eventually realizing that this was, required by the SEC, and he was really, really unhappy. We had a lot of evidence around his reaction to that Mercury News post. So part of the answer is we've already got something in terms of social responsibility where the SEC makes you disclose that delta, and it's interesting how that data is being processed in the larger society, but we know how it hit Mr. Musk and his company.
I know Gwen is about to give all of us the hook to end this webinar, but I just want to ask one last question. Will this case have any impact, do you think, on Delaware law going forward?
This case is going to be one that's in the textbooks 20 years from now. And as Jeroen said, it's a masterclass in how to do compensation in the public company context. And those that don't pay attention to this are going to find themselves in trouble. So the answer is yes, it's going to have a profound impact on Delaware law going forward.
I'm afraid we do have to end the webinar now. We promised an hour. I do want to mention that our next webinar on July 9th is on FTC bans of non-compete agreements and the implications for business. It will feature our own Professor Laurent Idemlium, Professor Matt Marks from Cornell. For now, we're a little over our hour, and I want to thank you, Larry, thank you, Jeroen, thank you, Greg, for a conversation that clearly could have gone on for probably another hour. But thank you all.
Thank you for having us. Thank you for having us.
A pleasure.
Thank you. And thank you, Max, for making it possible.